Back to the council. Any additional questions for the staff, having heard the public speakers? Anybody have any? Councilmember Morehouse?
Thank you, Mayor. I wanted to get a little clarification in terms of, I didn't know if I was mixing issues. The issue with Pierpont is there's one about the energy and how that's utilized in the bringing structures up to code, but the one specific to the Pierpont is whether or not they can even have second DUs from a certain time forward. And when we're talking about zoning, we're not talking about building standards. So when Mr. Moss was referring to the resolution that's in existence, which is referring to zoning, I just want to make sure I'm following the train of thought there. Take a stab at that.
I'll take a stab at that. I think Mr. Moss was referring to two things. One was language that was in the original amnesty ordinance in which Pierpont was specifically excluded. So Pierpont was not included in the original amnesty ordinance. And there was language that specifically stated that it was in the ordinance, which is attached as one of the exhibits to this matter. And it's on page 11. It says this ordinance shall not apply to second dwelling units for which the owner can demonstrate, has a long explanation for two exclusions. One is second dwelling units that precede the date of annexation into the city, period. And then there's an exclusion for second dwelling units in the Pierpont area, specifically as to those properties subject to Ordinance 7713. 7713 was the one that was put up on the screen,
Right.
which basically declared that all of the properties that were being annexed at that time, pursuant to that ordinance, were to be deemed legal non-conforming uses. So whether they were in compliance with the Ventura City codes it didn't matter. They were going to be deemed to be in compliance at that period of time. And those are the two things that I think he was referring to, and he may have, and nothing in either one of those sections has anything to do with the energy code, as you correctly pointed out.
Yes. I mean, we're talking about more like a zoning issue. Are second dwelling units allowed? And then I guess, again, in trying to understand what was, if the ordinance of 7713 says, yeah, we will allow these types of units, and no matter how they're built or what they look like or what they're made of or anything else, they are as is.
Right, any unit, any house, any structure, anything that was in place as of 1977 was deemed to be legal. It may be non-conforming, but as you know, it's a legal non-conforming use unless it's enlarged or expanded in some manner, and then they lose that designation and they have to comply with current zoning requirements.
And the idea being that if there was some alteration post 77 with the annexation, perhaps without permits or proper permitting, then they were suddenly out of the grace period of being exempt.
That's right. You have to comply with the zoning that's in effect at the time that you construct something, unless you have some sort of an exemption, such as a legal non-conforming use exemption.
With regards to the question of, I'm just curiosity. Did the state energy codes, or did those come out of a result of Assembly Bill 32, which got into the whole thing about global warming and greenhouse gases? Suddenly, we're much more energy cognizant because we had all these mandates that everybody had to meet by 2020 under dear Governor Schwarzenegger, or what happened?
The energy codes came into effect in 1978. I think that preceded most of that discussion of global warming.
All right. And if there is, as contended by some of the speakers, that we are over-interpreting how the energy code is to be applied, that we may be able to have a little leeway. I guess this goes back to the city attorney. In what capacity are we liable in any way by, if anything happens? I mean, this again, as Councilmember Tracy pointed out, this isn't a life-threatening safety issue, but it is another requirement, as our building official believes it to be. Where does that put us in terms of a corporation if something happens, somebody.
Well,
after-
if there were to be liability, we would be afforded immunity under the government code for failure to enforce the law. There's a specific immunity provision in the California Government Code that provides immunity from liability for public agencies for failure to enforce the law, and that applies to lots of different provisions, not just building and safety and things like that.
Okay.
So if, for example, if you're envisioning a scenario, I know, if you're envisioning a scenario where someone were injured in some manner as a result of the city not coming out and doing their code enforcement, whether it's the energy code or anything else, the city would have a defense to that allegation in court and in the form of an immunity from liability for failure to enforce the law, and that would include the energy code here.
Okay. And finally, and I don't know, Mary, you may have had this on your list too, but I just, since Ms. Purcell raised the question, and I think staff was feeling like they wanted to answer the question of whether, can you be subject to prosecution? There was a language thing. It sounded like the person could be prosecuted while they're working towards the end, and then once they reach the end, they're off the hook. But I didn't know if that, how the response to that was to be.
The answer is no.
What I thought, but I just wanted to be sure. Those are all my initial questions. Thank you, Mayor.
Councilmember Tracy?
Just a couple of follow-up questions, specifically with regard to Mr. Stanley's comments that the energy codes by law only apply to new construction and that our only safety codes are retroactive. Could you comment on that?
Yes, I'd be happy to. I think that's being taken out of context. If you go to the law explicitly says if you issue a building permit, the energy codes in effect at the time of the building permit apply, full stop. When you have a law and there are different parts, they have to work together. You can't read them to conflict. And so the interpretation that's being provided by members of the public would conflict with that. Now, what they're taking out of context to me, it seems, is the statement that the energy code shall apply only to new residential and non-residential buildings on which actual site preparation and construction have not commenced. Basically, that's giving you, if you've started preparing the site or constructing, you're golden. The energy codes that you did the plans under and you are constructing under, you're safe. Even if new codes get imposed while you're constructing or building, you're fine with the codes once you've started constructing or building. It's basically a provision in there to prevent a gotcha. You've got the plans, you've started constructing, and you're on your way, and now the state can't come in, no one can come in and require you to comply with new codes. That is how I read and interpret that section of the code. And with respect to the opinions given from the Brandt-Hawley Law Firm and Morrison Forrester, I can opine that this letter from the Brandt-Hawley Law Firm is, Susan Brandt-Hawley is an expert in historic preservation and also CEQA. And so this letter to me seems to be phrased in the context of vintage second units in Ventura, and so it's looking at it from a historical preservation viewpoint rather than a interpretation of the energy code viewpoint. And I believe she's taking that energy code out of context as well. And with respect to the interpretation from Morrison and Forrester, also I believe that was a first-year associate with whom I spoke who had never done any work with the building code, and so I don't give that much weight either. And last, with respect to liability, I would not add anything about liability, but I did find that in the Energy Code, if the local building official fails to enforce, the State Energy Commission has the ability to come in and enforce in his or her place. So that would be one consequence of failure to enforce. The state could do it, step in and do it for us.
Okay, thank you. And then on the energy codes themselves, they went into effect in 1978, is that correct?
That's when they started.
But they've been modified over time, right? So what was in effect in 1978 is more stringent, or there have been additional requirements since then, is that correct?
That's correct. And the subchapter 9 of the Energy Code deals specifically with additions and alterations to residential dwellings, and it only requires that those elements of the dwelling that are changed to be brought into compliance. So if in 78 or 80 you put new windows in, and now you wanted to put a new heater in, you don't have to change your windows out, just the heater needs to comply with the new standards. And likewise, there's a section to add to the applicability of the code to only new buildings. This section specifically addresses alterations and additions, and in alterations, it specifically addresses alterations to existing residential buildings or alterations in conjunction with the change of building occupancy from a low-rise residential or to a low-rise residential occupancy shall meet, and then it lists out the requirements in the Energy Code for how they have to comply with that. And this is where we have garages that are converted to houses, and they need to now meet the housing standard for energy as opposed to the garage standard.
So if you had a second unit, the date of construction, or the date of, I think you call it in service, the date it was put in service is 1977, would you still be, what would be the energy code you'd be required to apply to?
The current energy
The
code.
current energy code, okay. Okay. And then with regard to Pierpont, I have two questions that came up. First of all,
Actually, I'd like to qualify that answer because if the structure was previously permitted as habitable space, places where people lived and lived their lives, not a garage, not a shed, then it doesn't need to meet, and it was legally permitted as, say, a family room, and now it got turned into a second unit, it does not need to meet the energy code requirements, the new energy code requirements, because it met whatever requirements were in place at the time it was built for that use, that habitable use.
so in the case, it would only apply to a second unit that was built separate from the original property without permit.
That was not originally built as habitable
right.
space. Was a garage or a shed or something not.
And it wasn't permitted. I mean, in other words, it could have been built in 1978, and if it was built in 1978 and inhabited, then which code would it be? Would you still use it? Then would you use the current code, the current energy code?
We would use the current energy code, yes.
Okay.
If it was built as a new building, yes,
Okay.
in 78.
Did you have something you wanted to add, Mr. Byron?
I just wanted to state that I believe what Mr. Stoeffler is saying is that it's the change in use that triggers the need for a building permit. So this is essentially a two-step analysis. Is there a change in use going from, for example, non-habitable to habitable space? That triggers the need for a building permit. That is clear. And then once you have the need for a building permit, that's when that triggers the energy code. And so that's how staff has been analyzing it, and that's how we interpret it to apply.
Okay, just to make sure I understand this. If I build a house in 1977, and it's 3 bedrooms, 2 baths, 1 kitchen, somewhere along the line, I add a bathroom and a kitchen and divide up the house somehow to have a duplex. And now I want to do a second unit amnesty process. What would be my requirement under the code?
Under the energy code?
Yes.
You would not need to make any improvements,
Okay.
energy code-wise.
Okay, and then with regard to Pierpont, first of all, do we have some, I mean, you may have said something about this earlier in the meeting, but that was an hour and a half ago, so I forgot. Do we have an obligation to involve the Coastal Commission at this point to implement this second unit amnesty program in the Pierpont or in the coastal zone?
No, we don't have an obligation to involve the Coastal Commission because we're complying with our current coastal zone requirements. So there isn't an obligation to involve them. If we were going to pursue making changes to the ordinances, then yes, we would consult with them about a forthcoming LCP amendment. I think one of the speakers referenced, I think it was Mr. Moss, about the coastal zone, or actually maybe it was Leslie, and promoting affordable housing. Yeah, so there are provisions in the coastal zone that do support affordable housing. The change is that LCPs in and of themselves are not required to address housing policy. That stays within the local jurisdictions through their general plans and their housing elements. So there's not a coastal requirement to address housing policies and programs, but they have language in there that supports affordability. I'll remind the council that in our housing element update, which we just did this last year, second units is one of the programs we have in our existing housing element, and in the new one we just started effectuating as of 2014. But those units are not part of our RENA. They are hopefully to be produced in the city, but they're not specifically tied to RENA, and that's because we'd have to show that those units are retained in affordability requirements, including the provisions of ensuring that they are new units, not old units. So as you recall, we had that debate under that program at that time. So we do have a program for it, but it's not tied to our RENA allocation or requirements that we need to comply with.
Thank you. And then the last question is, what was our commitment to the Pierpont Council with regard to securing their input on this, and did we in fact do that?
I think Mr. McCaskill makes a good point. Staff didn't have our decision ready for publication until the last week before we came to council. We were talking about Pierpont and how we were going to deal with it, and it's as you can see, it's a fairly complex, and as we looked at the annexation dates, we considered different options, ran them by David's shop. So we didn't have the information to sit down with them and tell them where we were headed or what we found until the 21st, and at that point we did and met with them, and they provided some really good feedback to us about specificity and making sure that we look at this and provide a lot of clarity that we maybe didn't have in the past, so we tried to accommodate that. But I think their point is well made. There was only a week of engagement with them.
Okay, thank you. That's all the questions I have.
Okay, Deputy Mayor?
Thank you, Mayor Heitmann. Is there any harm in writing to the Coastal Commission, signaling to them our interest in potentially revising our zoning standards, and then saying, what say you with respect to the Coastal Zone Act? What are your thoughts on that?
In whether we would process the amnesty program? Or
No, just what their response is.
we can certainly ask.
We haven't done it in the past, have we?
Not on this issue, no.
And then the other comment I have, and also there's a question wrapped inside it, is obviously this is now shrouded in a significant amount of uncertainty, and there's trepidation, and that's understandable. Is there value, and I ask this of Ms. Scott, in having outside counsel who has expertise in construction, code enforcement, and land use law in weighing through these issues? Because I'm looking at moving parts, California Public Resources Code, Health and Safety Code, Historical Preservation, Energy Code compliance issues. And I just wonder if at this point, given all this uncertainty that's swirling around, if we say to ourselves, you know what, we need someone who's neutral, detached, has no skin in this game, is completely impartial, have them review the body of work, and then come back to council with their thoughts, recommendations, both with respect to the implementation or lack thereof of the energy code requirements, but also on how to proceed if we want to with respect to the Coastal Commission and modifying the local Coastal Zone Act.
Well, if you feel like you would like another attorney, I mean, you know, you can get as many attorneys as you like to look at an issue. If you feel like you would like another attorney to give you an opinion on the energy code, we can certainly do that. In terms of the local coastal issues, the Coastal Commission, I mean, we could also do that, but what Mr. Ward has told you is correct. It's a very long process to amend your zoning code in the coastal zone, period. I mean, everybody will tell you that. I mean, if that's the council direction, we certainly could hire someone else to go through it and walk you through it. But at this point in time, what's before you is just extending the amnesty. There's been no issues that I can see, and maybe you have some other questions. I'm certainly happy to respond to them. In terms of the actual amnesty provisions itself, you can either extend it or not. You can either extend it and apply it to Pierpont area or not. Whether or not any of the people that are in the coastal zone would be able to apply for any kind of zoning variance, which is available to others throughout the city, is going to be dependent on the coastal requirements. And we can certainly get somebody else in here if you'd like, if it's the direction of the council to walk you through those. But they're going to tell you the same with the coastal requirements in particular. It is a long, long process, and this city has worked with the Coastal Commission on a number of issues over the years, and many cities have, and they will tell you it's a long and difficult process. If it's the direction of the council to look at that, you certainly can, or if it's the direction of council to get additional legal advice on that, that's certainly your prerogative. That's certainly your prerogative.
Okay, thank you.
That's your only question? Okay, right now. Councilmember Monahan.
Thank you, Mayor. I've got a couple of questions and a comment. So I'll start off by going back to what Mike Tracy was talking about, this home that was divided essentially into a duplex, before 1977, and that what he had to go through and didn't comply with the ordinances. Well, wouldn't have to comply with the energy ordinance, I'm saying. The reason I'm asking this question, I've been called this week by a gentleman who wanted to do exactly that to a single-family home in Ventura, convert it into a duplex. Would that have then to come up to the energy requirements if you're going to completely change the use of that building?
Well, see, we wouldn't see that as a change of use. It's a single-family home now. It's habitable space. The energy requirements are keyed on that habitable space feature.
Yeah.
If it becomes a duplex, it's just 2 units of habitable space. They'd have to go through the building permit process and the planning process, but no energy code requirements would be.
Okay. That was the one question. And then in Ojai, I think they do call their second unit, they do qualify, I think, as a part of their affordable housing community. They do count them as, you say we do not, because it has to be a new unit, or?
I would defer to David on that.
Okay. I don't know which one.
Yeah, my understanding, and this was communication with state HCD, because this was raised by a member of our community during our housing element, and I did research that. And the state representative, Paul Dougal, indicated that there again, they were not requiring those units being counted as their RENA. And they were going through the process, so I don't know what ultimately got certified, but I did research that at the time because it was a question by the public during our certification process.
Okay, thank you. What I'd like to do then, I'm going to go ahead and offer a motion that we approve the extension of the second unit amnesty program with two changes, 2 amendments to that. One would be that we include the Pierpont community, and so they'd be treated as the rest of the city. And secondly, that we remove the energy code requirement from the second unit code. That's my motion.
I'm hearing no second. I'm going to call on Councilmember Tracy.
Thank you. My issue here tonight is more with the, really specifically is with the Pierpont community, and I'm not sure that we've gotten their input as we promised them that we would, and I'm not sure if we would want to divide those 2 issues somehow tonight, consider the ordinance without the Pierpont at this point, and then over a course of whatever we think would be an appropriate period of time, engage them and see how they might fit into this ordinance, or just simply postpone the matter to maybe to a date certain and reconvene after we have their input. I guess I'm throwing out that out for comment from other council members.
Okay, Councilmember Morehouse.
Thank you, Mayor. I think I'm kind of going along the same lines as Councilmember Tracy on this. It does seem that, and even by Mr. Stuffler's testimony, that Pierpont needed a little more time and probably some clarity for that issue. One thing, well, first of all, with regards to the Coastal Commission process, and just if this will help the deputy mayor as well, just having lived in that world myself and gone through that process, it's horrendously long, and that's an agency that I swear is like Alice through the looking glass. Every time you go in, it's upside down and backwards and will drive you insane. And as Mr. Ward offered up, be careful what you wish for, because sometimes you'll get more than you ask for, and then you're really stuck at that point with their blessing. So we have to be cautious before we explore that. Let me say something else. And I'm trying to figure out a diplomatic way to say this, but I feel like there's a little contention in here that is almost venomous towards our staff. And this shouldn't be a contention. Staff is a neutral body. These people are hired by us. They are sworn, much like a police officer, as agents of the court to uphold the law. They don't have a bias. They do the bidding of this group up here, which is trying to find its way for a community standard based on a number of things. And they have brought forward to us their interpretation of the law as they understand it, and are asking us if we should enforce it that way. It's when individuals go out and ask whomever as a citizen, that's fine, you can do that. I could call up anybody and say, hey, you know, if you're in the Energy Commission or whatever, fine. But we have it as an official to an official, and at a certain point I have to lean towards the expertise of these people because there's an official connection. You can ask any question you want, and these people respond, but there's kind of a thread of continuity, and I have to put some reliance on these individuals. So this give and take over the interpretation of the energy part of it is a little frustrating to me, and I don't want to rush. You know, I just feel a little bit defensive about our staff here, who I don't think they're on any particular crusade. I just think that they have a belief that how the law is to be interpreted. I think if push comes to shove, it's not the place I would suggest anybody go in litigation, but if there's a disagreement, I suppose the courts have to decide that. We're right or they're right, you know, one way or the other. But this kind of viciousness towards the staff as if they're on a witch hunt, I just wish we would all be a little more considerate of that, because they are neutral. They're doing something we've asked for. You may not agree with their interpretation. You've brought forward a number of pieces of information you think are different in your interpretation, and certainly it begs asking further the question. But if the answer never comes back the way you want it, we have to sooner or later let the ball spin and land in a slot somewhere on the roulette wheel, and I think I'm going to probably put my bet on the people who came in with a certain neutrality and did our asking and research accordingly. That being said, I think I would go ahead and follow Mr. Tracy's lead and suggest that we give, at least for the case of the Pierpont, a little more time, and maybe we should put this out for a time certain as well. I will not offer that in a motion right this second to give other council members a chance to weigh in, however.
Deputy Mayor Nazarenko.
I will join in that motion. I would also, so I will join in that sentiment. And with respect to the energy code requirements, I would like to make a motion at some point that if we do table that portion of today's agenda, that we just get another opinion from outside counsel. I would ask Ms. Scott if there's a collective concurrence from the body to retain somebody. It would just help me, because I now have so many conflicting legal interpretations, and I just want an additional one in order to satisfy myself and come to closure on this issue. So I will be at some point moving for the council to, within the time period between now and when this comes back, to ask Ms. Scott to retain outside counsel for that purpose.
Okay, I have a question. We have actually extended this amnesty program to December of 14. Is that correct?
You have given staff direction to continue to accept and process applications. However, the ordinance has not been amended yet.
Okay, was never officially amended even.
That's one of the
Okay,
reasons why we're
okay.
back, for that official ordinance piece.
Right,
And if I could add, Madam Mayor,
sure.
unless the staff here feels differently, postponing a decision doesn't cost us, the city, money. It still leaves uncertainty in the community, which isn't good. But just, weighing the benefits of taking more time and not taking more time, there's, from a city standpoint, I don't see any additional expense.
Well, let me ask you this. If we're continuing to process applications for under the amnesty program, are we asking these people, these new applications, to have to comply with the energy requirements?
Everyone who's applied since July of last year.
Yeah.
Yes. So and that's
So-
something you could decide tonight. You could give us direction without it being in the ordinance.
Say that again?
I don't believe, unless our city attorney feels otherwise, you could give us direction on whether or not the energy codes apply to the second unit amnesty program without having an ordinance amendment.
Right, I mean, you're giving direction to staff regarding the enforcement of the code, which is what the Energy Commission said the city can use its discretion. This is for a very specific purpose. I mean, we stand by what we said before, which is we think in the city attorney's office that it applies regardless. But you know, if the Energy Commission is the enforcing body and they have told our staff that they're going to leave it up to you, you know, as part of the amnesty program, if that's your direction, you know, that's what staff's going to do. But we've also got the issue of then, you know, when it ends and all that. And just to reiterate, as it stands right now, Pierpont is exempted from the amnesty provisions under the terms of the original ordinance.
So,
So if you leave it as is and don't make a determination tonight on this extension, they're still excluded. If you want to include them, you still need to do that affirmatively because they are excluded as status quo is that they're excluded.
right, but just to understand, if we include them tonight, we're including them only on the post-70, no, the pre-78, 77, okay, pre-77 second units, and we would be excluding anything from there forward at this point.
Well, you're not excluding them from the amnesty program, but it's highly unlikely that they would be able to comply because only those that currently have legally non-conforming use zoning are in compliance with the zoning code. Just like everything post 77 is the same as everything else in the city. They either do or don't comply. If you're in a different zone right now and you don't comply with the current zoning, in addition to applying for your building permits, you would have to apply for a variance or something like that. You still have to bring the zoning up to code.
Right.
It's just unlikely that any of the properties in Pierpont that are post 77 that don't have this legal non-conforming status could ever comply because of the local coastal
Right.
requirements.
Okay, so we could essentially tonight give direction on this ordinance regarding the energy codes and including Pierpont, and in addition, give staff direction to continue to investigate whether we want to change the zoning in the Pierpont, or it's not just Pierpont, but in that area, that would deal with the post 77.
That's not on your agenda tonight,
it's
the actual
not.
zoning. I mean, that would be something
Okay.
to bring back to ask, to
Right, that's
direct
what I'm
staff
saying.
to look at that.
That's what I mean, that was
Right.
exactly what I'm saying.
But
That we could
tonight,
direct that.
you would direct them to bring that back to you,
Okay.
you know, the.
Okay, so that's the motion I'm going to make. I'm going to make a motion that we extend the ordinance to December, whatever it was, I'm sorry, you give me the exact date, 2014, excluding the energy code requirement and including the Pierpont, with the additional direction to staff to investigate the zoning that we've been discussing in the Pierpont, or whatever that official title is, area, to bring back so that, in other words, we would have the time, no, I'm editorializing, not in the motion. We would have the time for Pierpont residents to weigh in on whether they would like to see a zoning change for the post-78, 77, second units, but we wouldn't be including them in the pre-77 units in this motion. Is that clear? No. Okay. It's not clear. Okay. Well, we're going to clarify it then. It's a lot of free thinking.
No, I think I was following. It would not apply to those units post 77.
I'm sorry. That's what I meant.
Yes, I was following you.
Okay. Okay. But we would be giving additional direction to investigate. It is to really just so that we have the discussion with the community on what they really want to do in terms of going back to coastal to change that zoning. Okay.
No, that's
Thanks for doing that.
Do you need a second if we're going to?
Just got to see it.
Oh, see,
Well,
we
if I
want to
could-
see it first. Go ahead.
I would add, weighing in on the last line, on changing zoning requirements for post-78 second units.
Madam Mayor, the ordinance,
Yes.
the ordinance before you tonight, you don't have to direct us, because the ordinance does extend the program to December 2014. You can tell us, the council can tell us tonight, don't apply the energy code to the amnesty program. We don't have to amend the ordinance, because there's nothing in the ordinance about the energy code. And it would already include that portion of the Pierpont area that, as it's shown based on annexation date in the interim, while we go back and engage Pierpont, see if we can expand that further or do a zoning change.
Really? Because that was not my understanding. I thought my understanding was that they weren't included, they were excluded. But was pre-78 included? I thought that wasn't, I thought the Pierpont was excluded completely from this.
No, the pre-78 was already, because they already have a legal non-conforming use, they don't need amnesty from the zoning
Oh, I
requirements.
see what you're saying. Okay, fine. I see what you're saying. You're just clarifying that. Okay. So you're saying we don't need to do anything on an ordinance if the ordinance was already passed to extend the amnesty to? This was my original question, which I thought I got a different answer.
I'm sorry, I've confused you. There are two ordinances in the admin report. One is the original, Pierpont's excluded. The second is the amended ordinance, and it achieves your first two objectives here. It extends the ordinance to December 2014, and actually your first objective and your third, and it includes a portion of the Pierpont area, although it sounds like not really maybe the way you'd like it, or maybe you'd like us to look further into that. And then in the energy code, you can just give us direction.
Okay. Okay.
In other words, this is the ordinance that's before you.
That's what I thought.
Is to, and then you're giving direction to staff on the energy code.
Okay, that's what I was trying to ask before, and I didn't ask it well, I guess, because that was my understanding, but now, okay, we're all on the same page. Yeah. Okay. So basically, all you need from us then is direction on the energy codes tonight.
Direction on the energy code, and to tell us if you'd like us to continue engagement with Pierpont to look for opportunities to expand their involvement.
Okay, so I would then amend this to say, basically, to exclude the energy code from the ordinance, and that last part, about allowing residents to weigh in on changing the zoning requirements in the post-78.
And I think, Julie, don't they have to say they want to adopt the ordinance and bring it back for second reading?
Yeah, that's what is before you tonight. So you're moving to adopt the ordinance, to waive the first reading and adopt the ordinance that is before you. And in addition, you're directing staff. You're doing two things, or at least you're proposing to do two things. And secondly, to direct staff that for the amnesty properties not to apply the energy code at this time. So your motion is to adopt the ordinance.
Excluding the energy code.
No, and then that's really a separate item. So you probably should make two motions,
Oh, so it's two motions.
or two parts. The motion is to adopt the ordinance, and then secondly, to sort of, that's A, and B is to direct staff
Okay.
to forbear enforcement of the energy code provisions as to the properties that come in for the amnesty.
Okay. And then the third part of that would be to direct staff to continue to work with the Pierpont community on the post 77
Zoning
zoning, okay,
issues.
okay. Do we have
You
it?
wanted to say, so be it?
So, yeah, for sure.
Then that effort by, but that effort by staff then would come back as an amendment to the ordinance?
No.
Or how does that come back?
That would come back as a completely separate item to basically look at possible potential zoning changes in the Pierpont area for second dwelling units.
Well, then I would recommend we put a pretty short timeline on that, because this ordinance is running out. So if we're going to include that, I would recommend we put a date certain to come back to council with
Right.
that.
With the understanding that, it's going to take a long time.
Well, we're not, yeah, exactly, but that would be part of the discussion that would be held
Right.
with the community to decide if that's something that they're interested in doing. So what would the staff feel about a date certain? What would you be comfortable with?
I would, speaking on behalf of the director, I would have a July date, one of your council hearings in July. That gives us at least 2 months, and formulate a response back, so it'd be a director's report back to council on a work plan item if it's an initiated in a zone change. But I think by July would work.
Okay, because I think basically we're talking about just gathering the information, having the discussion with the community to figure out if they even really want to pursue this any further. Okay, so you're thinking July, okay. So we say the first meeting in July?
That would be fine.
Is that, okay,
I'll second that.
okay. So are you seconding the motion?
Yes.
Which we think we have, but,
Yes.
yes, okay. Okay, Deputy Mayor, do you have another comment?
I was just going to second.
Okay, Councilmember Monahan?
Could have the clerk read the motion that we're voting on? I think everybody here would like to know what it is.
Relax.
Okay, is everybody clear? Okay. Councilmember Tracy?
I just want to make a comment, and that is that, first of all, I think our staff has given us good advice. I think you've told us what you truly believe, and you followed your, professional standards in every way. And the fact that we are now, from my perspective, the reason I am supporting the deletion of the enforcement of the energy codes is simply to make the program consistent from start to finish. And I did not participate in the decision to adopt this program because I had a conflict with the property that I own. Had I been able to, I would not have adopted this program. I think that the problem in this community has been totally mischaracterized by a segment of our community. I think that enforcing our building codes is good for everyone. It's good for property owners, it's good for people buying property, it's good for people selling property, and it's good for people living in the community. And I think that it isn't an issue of rich versus poor as much as people want to characterize it that way. It's not about forcing elderly people out of their homes. That's not why we went down this road. I think it was a mistake to do it in the first place, but we now have it, and we're going to get to December 31st of this year. And as long as I'm on the council, I would not support any extension of this program. I wouldn't support a continued program in any way along these lines. I think it's been a mistake. At this point, let's get it done and get down the road. But I want to just say that I appreciate all the work that our staff does on this, as Councilmember Morehouse noted, you've been doing what we've asked you to do from start to finish, and I venture to say that if it had been your choice, maybe some of these decisions would not have been made, even the initial inception of the program. But we're here, so thank you for your work.
Okay, and I'll just add, I want to thank you also for your patience tonight and all the work you've done on this, because this is not an easy issue, and there's many moving parts to it, obviously, and it's been a learning experience, I think, for everyone, because it's new, uncharted territory. So, and for the community also, who's brought us information and continued to work with staff. And it is, I think it is important what Councilmember Morris was saying, that we hope this is a partnership, that we are all working together to improve our community, and we do want our dwellings to be safe. And I think that's the bottom line that we all agree upon, is that we really want all of our buildings to be safe so that our citizens are living in, we could feel proud about where anybody's living. We'd like to be able to say we have a safe community. So I appreciate what you're doing to make that safer. And I think that is what your mission really is, and that's what you're trying to do. So I want to thank you for that too. And for the citizens who are working with us on that partnership. I think that's really important. Councilmember Morehouse.
Thank you, Mayor. I'll speak to the motion, and I find myself somewhat concurring with Councilmember Tracy in that moving forward is important, and having the cutoff date is important. This could be protracted forever, and we did start down this path. And again, it's no derogation to Mr. Stuffler and City Attorney's Office, anything else on the Energy Code. I guess this one we'll find out if somehow or another the Energy Commission knocks on somebody's door. And that's their right and prerogative, and that would be very interesting if that happens. So that, to that end, I will go ahead and support the motion as it's structured.
Okay, seeing no other lights, I believe we're ready to vote.
Madam Mayor, I didn't
Yes.
hear who the seconder was on the motion.
Seconder was Councilmember Tracy. Okay, we're ready to vote. If you could take the roll call vote, please.
Councilmember Morehouse?
Yes.
Councilmember Tracy?
Yes.
Councilmember Monahan?
Yes.
Deputy Mayor Nazarenko?
Yes.
Mayor Heitmann?
Yes, that motion passes 5-0. Thank you. And we are now going to take a 5-minute break.